Hi, this is Sai Deepak. I am a senior associate at Sai Krishna and Associates. I have been practicing law for the last 5 years before the High Court of Delhi. The module that I shall be dealing with is intellectual property and competition law. The general assumption when it comes to intellectual property and competition law is that they are at conflict with each other, they are at loggerheads with each other. This has not been my understanding so far, because I see competition law as a limiting factor or as a limiting agent that ensures that intellectual property rights or the exercise of intellectual property rights does not result in market failure. Therefore, I see this as an extension of the conditions or restrictions imposed on intellectual property owners under IP legislations, except for the fact that this is a limitation or a restriction that is imposed outside the IP legislations and in a different legislation. What is also important to understand is that limitations that are imposed on IP rights within each of the IP legislations have a different bearing. They are meant to protect the realm of commons. They are meant to ensure that intellectual property owners do not go to the extent of curbing rights that are otherwise available to third parties or to members of the public. The object of the competition law is to prevent market failure by exercise of IP rights or by abuse of IP rights. Since we speak of abuse of IP rights and anti-competitive practices, it is imperative to have a reference or regard to the framework of Competition Act and its references to intellectual property. The two prominent provisions where intellectual property finds mention under the Competition Act are Section 3.5 and Section 19.4G. Section 3.5 is basically an exception to Section 3, which deals with the aspect of anti-competitive agreements. Section 3.5 says that nothing that an IP owner does with the object or the intent of preventing infringement of his rights and imposes reasonable conditions pursuant to this particular object shall amount to an anti-competitive agreement within the meaning of Section 3. Section 19.4G, on the other hand, basically forms part of those factors that the Competition Commission shall have regard to in its analysis of whether or not a party is in a dominant position in the market. Section 19.4G refers to any monopoly that is granted or that is acquired by way of a statute, which may lend a position of dominance to an enterprise. Since it refers to any statutory monopoly and there is no exemption for IP rights or there is no exclusion of IP monopolies, so to speak, it would be fair to assume that Section 19.4G of the Competition Act is broad enough to encompass within its ambit all forms of intellectual property. Now, this has two different implications altogether. As far as Section 3.5 is concerned, although it is an exclusion or an exemption from the application of Section 3, it is a limited exclusion which permits only reasonable conditions that may be imposed by an IP owner on third parties with the object of preventing infringement. However, if the condition has absolutely no nexus to this object, or even though it may have a nexus to this particular object, the condition may otherwise be reasonable, it would be perfectly legitimate for the Competition Commission to intervene and to prevent the perpetuation of that iniquity and to treat that agreement as an anti-competitive agreement. The point that I am trying to make is simply this. One of the common perceptions is that Section 3.5 completely pulls out exercise of intellectual property from the scope of the Competition Commission's inquiry under Section 3. This is a myth. If one were to pay attention to the language, it is absolutely clear that should the IP owner go beyond the limitation of reasonable conditions and goes beyond the object of preventing infringement and imposes conditions with a view to delay the entry of a third party's products and by default extend his monopoly, it would be legally justifiable and it would be legally permissible for the Competition Commission to take cognizance of this action or this conduct. Similarly, as far as Section 4 is concerned, when the acquisition of an intellectual property gives rise to a position of dominance and the dominance or the position of dominance is exercised or used in such a way so as to cause injury to third parties and injury in a manner that is prescribed under section 4, it would again be permissible for the Competition Commission to intervene. So for instance, if the owner of a patent who has close to 30 to 40% market share by way of acquisition of that particular patent as far as that technology segment is concerned, imposes unfair conditions or resorts to predatory pricing or resorts to bundling or resorts to any other prescribed activity within the meaning of section 4, it is possible for the Competition Commission to treat that conduct as abuse of dominance. One of the arguments that has been presented on a regular basis and that has also been treated as justified is that each of the intellectual property legislation is a self-contained code or is a self-contained legislation, and that inequities that could arise from abuse of intellectual property are taken care of and are addressed by the IP legislations themselves, and therefore Competition Commission or the Competition Act does not have a role to play in curbing these inequities. I respectfully disagree for the good reason that there is no such exclusion of the applicability of Competition Act that finds mention in any of the IP legislations. In stark contrast, the Competition Act has provisions which make it abundantly clear that should there be a conflict with any other legislation or should there be a conflict with any other provision of any other legislation, the Competition Act shall prevail. Therefore, even if there had been an express mention in the IP legislations which prevents the application or excludes the application of Competition Act to each of these IP legislations, the Competition Act would have prevailed thanks to section 60 of the Competition Act that declares for everybody to see the overriding effect of the Competition Act. The one thing that we will also have to address is, apart from the aspect of overriding effect which kicks in the event of a conflict between the Competition Act and any other legislation, what happens when there is no perceived conflict or apparent conflict on the face of it between an IP legislation and the Competition Act? The answer to this lies in section 62 of the Competition Act, because it goes on to say that the Competition Act shall apply and shall be in force in addition to and not in derogation of any other law, which means so long as there is no conflict between the Competition Act and IP legislation, both these legislations will continue to apply on an IP owner. Therefore, if there are a set of restrictions that apply on an IP owner under the IP legislation, and there are a set of restrictions or limitations that apply on an IP owner under the Competition Act, both these restrictions will simultaneously apply and the patentee or any other intellectual property owner shall adhere to both these restrictions simultaneously. So for instance, section 84 of the Patents Act deals with the grant of compulsory licenses and spells out the conditions under which compulsory licenses may be granted. One of the conditions is that it is permissible for a person interested to apply for a compulsory license if the patentee fails to make available the patented invention at a reasonably affordable price to the members of the Indian public. Since it says reasonably affordable, the corresponding provision of the Competition Act which would be relevant for this discussion would be section 4, which deals with the aspect of unfair pricing as a part of abuse of dominance under section 4. Since section 4 of the Competition Act prescribes unfair pricing, and since section 84 of the Patent Act requires the patentee to sell his goods, his patented invention, at a reasonably affordable price, clearly there is no conflict between the two legislations or provisions. In fact, they complement each other. On the one hand, under the Competition Act, a patentee is expected to not sell his products at an unfair price, and on the other hand, under the Patents Act, he is expected to sell his products at a reasonably affordable price. In such a situation, both the Patent Act and the Competition Act continue to apply on the patentee. Had there been a conflict between these two provisions, section 60 of the Competition Act would have ensured that the Competition Act and its requirement would have reigned supreme, insofar as a patentee is concerned.